Good afternoon, everybody. Welcome to today's Republic of Work Lunch and Learn series. As most of you probably know, Republic of Work are a co-working space, and they drive their community through the growth and development of businesses and through utilizing their network and events such as this that we're at today. So it's a great place for anyone considering co-working space. My name is Dean Cunningham, and I am the principal of Cunningham Solicitors, a law firm that focuses on all things technology and IP. Of course, I also have a particular interest in today's topic, software licensing. I've spent 5 years actually leading the Dell Technologies IP governance team, and I am also, in fact, the legal partner here with Republic of Work. So if you ever are in and around Republic of Work, once these restrictions are obviously lifted, please feel free to reach out to me for a chat. So look, I have done my best to keep the presentation relatively free of the legalese and the jargon. My aim and my hope for this presentation is for each of you, the audience, to come away from it with a better understanding around the principles of software licensing, and and how to avoid the many pitfalls that exist when talking about software licensing. So without further ado, I hope you're ready to explore the wonderful world of software licensing. Okay, so here's our agenda for today's Lunch and Learn. We'll get the basics right first, which is really basic property law principles. And we will then differentiate between the different types of licensing arrangements and terms that exist. We will distinguish between what is referred to as an assignment versus a license, two very important distinctions and related terms, but nevertheless, they do quite different things, which you will see in a moment. I put together some videos actually that will hopefully bring all of this knowledge together in a kind of a fun way, and hopefully will be useful for you. And then last but not least, some key takeaways. Okay, so the basics. So before we move forward, to truly understand software licensing, it's good to pause and understand basic property law principles. So what is property? So legally speaking, what exactly is property? And we often use the word property in day-to-day parlance and not really understand the exact legal connotations of what we're saying. So property can be generally divided into two broad categories. Number one, we have tangible property, meaning that you can touch it and you can see it and it has a physical state. So a house, a car, a bike, whatever. And we have intangible property, meaning that you cannot see it, touch it, or hold it. So software as a property right fits within this intangible category of property under the heading of intellectual property. And I'm sure all of you have heard that term. So in fact, ownership of software is a unique form of technology and intellectual property in that it comprises of rights that are protectable under copyright, patent law, and trade secret law. So these multiple protections arise because software can be both a work of authorship, which is copyright, as well as a business process, which is trade secret, or it can indeed be the key component in the functionality of a machine, which would be covered under patent law. Okay, so again, along the theme of the basics, so we're now going to distinguish between a license and an assignment. So remember, property, the intangible, the tangible distinction, like all of it, like if you think about the totality of property rights, it's essentially a bundle of rights. And in law lecturers, like students are frequently given the example of a bundle of sticks. And if you own the entire bundle of the sticks, you have the complete legal ownership of property. So in order to exploit these rights, there's a number of different ways you can do it. So number one is a license, right? So a license can be thought of as the permission of the owner of property to use that property. So a software license is simply the permission from the software owner, the copyright owner, to use the software. So in that situation, the owner is not giving away all of the sticks in the bundle of sticks, right? He or she is only giving away some of them and retaining the majority stake in the property rights. So that's what a license is. Now, if we compare that to what an assignment is basically the exact opposite. And it means that the copyright holder, and in the case of an assignment, this person is referred to as an assignor, is transferring all of its rights to another party, which we refer to as the assignee, usually in return for a fee or perhaps some form of royalty payment. This is kind of what you don't want to do if you're seeking to sell a software license. If you do so, essentially what you've done as you've basically given away the complete bundle of sticks, right? And you no longer have any proprietary rights in the software. So therefore, when you're talking about software licensing, great care must be taken when you are drafting what is referred to as the license grant clause in the software licensing to exclude the eventuality of an assignment. And if you care to look at any of the major software vendors' licensing terms under license grant, you will see that, the likes of Microsoft and Dell, they'll be at great pains to distinguish that they are not granting an assignment in a given scenario, and it's primarily a license. And in fact, it's common practice to also exclude the possibility of the licensee assigning its rights also. So get those concepts clear in your head. License, it's permission to use it. Assignment is you're giving it away. Okay, so licensing terms and conditions. So essentially, a software license is a limited form of legal ownership granted from the licensor, again, the party granting the license, and generally the copyright owner, to the licensee, that is the party receiving the license. So when considering software licensing, like it would be remiss of me not to mention software as a service, as a delivery model. And I'm sure everybody has heard of that by now, right? So this is an alternative approach, and indeed it would warrant a separate session in of itself. However, I suppose the easiest way to understand it at this juncture is that the end user or the customer in a software as a service scenario is simply subscribing to a service generally hosted in the cloud by the software vendor, and in most cases is not granted a license to the software. Rather, they are simply given a license to access the service, which is of course the software. So there's a distinction there, and that's worth understanding. So terms and conditions, right? So there's frequently a myriad of restrictions and rights that can be contained as part of the license grant, and we will touch on those over the next couple of slides. Okay, the next term or condition in relation to license that I want to touch on is the distinction between an exclusive license and a non-exclusive license. So the licensee, where they are given exclusive rights to the software in question, this means that the licensor, again, the person granting the license, they cannot provide that software to anyone else for the duration of that license. It's on an exclusive basis, right? The opposite of that then is, of course, where the license is granted on a non-exclusive basis. And this means that the licensor is free to license that software as it sees fit to whoever it wants. So again, for example, Microsoft, Dell, Apple, SAP, Adobe, all of these big major software brands, they of course would license on a non-exclusive basis, meaning that they are free to license their software to whoever they want. Okay, the next licensing term that I would like to draw your attention to is the notion of perpetual licensing. And perpetual licensing can be a misleading term in that it seems to signify that the license will continue perpetually, it will continue forever. In theory, that is possible. However, such rights they're generally revoked where there has been a material breach of the contract, or perhaps where the perpetual rights are subject to an ongoing commitment on the part of the customer to pay a maintenance or support charges, and maybe they've not kept up with those commitments. And in that sense, then the perpetual license will stop. So some software vendors like to sell on this basis as it justifies charging, a large fee upfront. So let's say like €5,000 per perpetual license from day one of the licensing arrangement. Customers like perpetual model because they are confident the software is fit for their needs, say for the next 5 or 6 years. So like typically these customers, they just want to install the software and forget about it, right? Some software vendors will link the customer's rights to a particular version that was available at the time. So let's say version 5 was the version of the day, and they'll only allow the customer to upgrade to version 6 when either they are current on support, which is usually like maybe the support cost can be generally thought of about 25% of the license fee. And so what can happen with this model is that after a number of years, the version the customer originally bought is outdated by subsequent versions. And they are tempted, they're tempted by the new, latest and greatest new version, right? Now, the big tech companies can make this difficult and either insist the customer pay back support for the version upgrades that it missed, right, to bring them up to the latest version, or they will insist that they have to buy a whole new license. So the big software companies, they literally have armies of people watching exactly what version of the perpetual licensing customers are on. And there's armies of salespeople out there that are structuring deals to entice customers to get them onto the latest and greatest version. So that's perpetual licensing. Term licensing is, you guessed it, it's based on a term or a fixed period of time, meaning that all rights to use the software will expire once the end date has been reached. So some software vendors have, they've even built in functionality that will automatically turn off access to the software after a defined period. So it is essentially the same as a perpetual license, except it's limited in time. So generally, if a perpetual license costs, let's say €100, a term license costs roughly 25% of that. So, €25 for 1 year. Why do customers like it? Customers like term licensing when they need the software for a particular project, and they don't necessarily need a perpetual license, because once the project is complete, they'll have no need for the software in question, right? Software vendors like to sell term deals, particularly to large enterprises under what were referred to as ELAs, enterprise license arrangements. Sales teams will actively monitor the term deal, and roughly, about 12 months out from the end of the term deal, they will re-engage with the customer. They will start the process of entering a new contract. The customer is under pressure because it knows that come X date, all of this software stops working. So they're often eager to get a deal in place, and these can often be easy sells for the sales teams involved. Okay, geographical restrictions. It is possible to limit the licensee's rights to use the license to a defined territory, or even to a particular entity within a particular country, like a subsidiary maybe, right? So many software vendors will have different pricing for the same software in different territories. So for example, like the same piece of software could be more expensive in the US than it is in Ireland, right? And for that reason, it is common to have different contracts for the same software products for the same customers, but based on different geographical locations. Managed service provider licenses, or MSP. So MSP licensing is applicable where the licensee wishes to use the license to support its customers. So in other words, they want to make money out of it, right? They want to use the license that they buy from Dell or Microsoft or SAP, and they wish to use it to support their customers for commercial gain. Now, these are very common licensing terms in the IT managed service industry. In some cases, the MSP license will be linked to a specific customer, right? Whereas in other cases, the arrangement, the MSP is free to use it for whatever customer it wishes. Now, there's massive risk there as a software vendor for that latter type of an arrangement. So I would not advise it, but it happens. And really, it should only happen where the software vendor is heavily compensated. And the reason for this is because it's not uncommon for the MSPs to block out large parts of the market for software vendors, since, the prospective customers will have access to their products through the MSP. Okay, so understanding the exclusive, non-exclusive, perpetual, and term licensing that we just discussed, it's really only half the story, right? So the next issue to consider then is what counts as a situation or event that requires a license. So these are counting metrics and are often known as units of measure, or UOMs, or licensing metrics. So these can be found in the additional terms that are referred to in the main software licensing agreement. Sometimes they're the document that they're embedded in are referred to as a product guide, right? So in turn, then each licensing metric or UOM is linked to a unique price point in a price book, right? So common examples of a UOM include per server, per seat, per enabled user, right? Each term will then be linked to a unique definition and will essentially set the legal parameters around what constitutes a scenario that requires the purchase of a license. Look, the software vendors, they put great emphasis on the customers. You must understand how the software is licensed and how it should be managed without falling foul of the licensing terms. Breach of the licensing terms will often be considered a breach of contract and potentially entitling the software vendor to revoke the licensing and sue for damages. So let's say a customer has purchased 1,000 seats of product X. That customer's license entitlements is 1,000 seats of product X. Therefore, the customer should only install or deploy 1,000 seats of the product. If the customer decides, you know what, let's install 1,500 seats of the product, it is, of course, it's in breach of contract and has infringed the copyright in that software. The problems arise here from the customer's perspective when the definition of exactly what a seat means is vague and ambiguous, which is often the case. So for example, do you need 2 licenses where a user has the product installed on his work laptop and maybe on another computer at home? Or where a user has access to the product in a shared environment, say through a server or in a Citrix environment, but never actually uses the software? Does that require a license? So here are a couple of common units of measure, just to give you some context. And I'm not going to read them out, but you can see them there for yourself. It's enabled user, enterprise-based server, and a mailbox. Okay, and then another couple more there, named user based licensing, and what we just discussed there, the seat-based licensing. So what else do I have to say about units of measure? In my experience, most software licensing disputes come down to a dispute around the interpretation of the units of measure. And why, I hear you ask. And the reason is actually quite surprising. As I mentioned previously, the UOMs are incorporated in the main software license agreement through a hyperlink, right? So if you look at the main software agreement, you won't find these licensing terms in there. You have to access them through a hyperlink, right? And this will bring you to the product guide, and that product guide is generally contains a myriad of units of measure, and customers generally just don't read them, right? And I know that's surprising. But there are many high-profile software licensing cases out there that have turned on the interpretation of a single unit of measure. So if you want to read up a little bit more about it, a famous case is Diageo, the drinks distributor, versus SAP. And if you just Google that, you'll get loads of information about it. And it's particularly interesting in this context to see how, I think it was about £50 million the issue was resolved for, but how that case turned on the interpretation of quite a limited number of UOMs. Okay, so we've touched on a lot of different issues here, and what I'd like to do now is to play out a couple of scenarios to bring all of this knowledge together. So the next couple of slides contain some videos that will hopefully help you, see all of this coming to life. And I hope that I don't run into technical difficulties here and that everybody can hear the videos. So I've imaginatively called this the bike game. Solicitors are not known for their creativity, but nevertheless, let's give it a go. Okay, so the first scenario discusses an assignment of rights.
John owns a beautiful bike. John has a proprietary interest in this bike as the property owner. Paul wished that he had such a beautiful bike and would like to own such a beautiful bike. Luckily for Paul, John had decided that cycling is not for him and he needs to get rid of his expensive bike and agrees to sell it to Paul for €2,000. What John has done here from a copyright perspective is that he has assigned his rights in the bike to Paul. John will not get the bike back and he has relinquished all ownership of the bike to Paul. He effectively has sold the bike.
Okay, so obviously that was an example of an assignment, which means that you're essentially selling the product or the bike and you're stepping out of it. No residual or proprietary rights left in the product in question, in this case a bike. Okay. Sorry now. The next scenario describes a license.
John owns a beautiful bike. Paul wishes he had such a beautiful bike, but he knows that he could never really afford one. As a solution, John suggests that Paul can use his bike for 1 week for €10. In effect, what John has done is he has granted Paul a license to use his bike for 1 week and for a license fee of €10. Once the term completes, all of John's proprietary rights to his bike will revert back to him. In other words, he'll get the bike back.
Okay, that was obviously an example of a license, and the distinction there to grasp, I'm sure you all have at this point, is that John got the bike back in the license arrangement, whereas in the assignment arrangement, he did not. Okay. Okay, the next example is an example of a term license.
Paul is walking by John's house and it's a terribly hot day and he wishes he could get home quickly and out of the heat. He asks John, can he use his bike to get home? John agrees to let Paul use his bike to cycle home on the condition that he stays on the main roads, returns the bike within 24 hours, and pays John €10. What has happened here is that John has licensed Paul the use of his bike subject to certain license limitations. Geographic scope is the main road, the term is 24 hours, and the license fee is €10. And unlike in an assignment scenario, John has retained his proprietary rights in the bike while also being able to generate an income. In other words, following the term 24 hours, the bike will revert back to John.
Okay, I think that's self-explanatory. That was just a term license and the term was for 24 hours. Okay, the next example is of an exclusive license arrangement.
Paul now likes the bike so much that he wants to use the bike more often and approaches John to make a deal. What John proposes is that Paul should license the bike to him on an exclusive basis for 1 year, and he must pay John €10 every time he cycles 10 kilometers. John has granted Paul an exclusive license for 1 year, meaning he can't license the bike to anyone else for this period. John has also created a unit of measure, meaning that Paul must pay €10 per 10 kilometers traveled. Again, as John has not assigned his proprietary interest in the bike and has merely licensed the bike, albeit on an exclusive basis, he will get the bike back after 1 year.
Okay. And the next example is about a perpetual license and what is referred to as a material breach and the consequences that would flow from that.
Paul now loves the bike so much, but he really can't justify paying John €2,000 to buy the bike outright. He wants to know that the bike is exclusively his to use on a perpetual basis without fear that when the term expires, John will take back the bike. John agrees to this arrangement and grants Paul a perpetual license to use the bike on the condition that he pays a perpetual license fee of €100 up front, limits the use of the bike to himself, and pays a yearly maintenance charge of €20. All goes fantastically well in years 1 and 2, and Paul dutifully pays his maintenance fee and abides by the terms and conditions of the license. However, in year 3, Paul decides to let his brother Tim use the bike to travel to work. John finds out about this and issues Paul with a breach notice and revokes the perpetual license. As Paul was in material breach of the contract, John was entitled to reclaim his bike and terminate Paul's perpetual rights, and John now gets the bike back. Let's assume Paul did not let his brother use the bike and continued to use the bike on a perpetual basis for the next 6 years. Paul starts to notice that the bike is not as nippy as it once was, and that there are lots of new and improved bikes on the market. Paul decides that he wants one of these new bikes and knows that John likely has one. He approaches John and asks about the newer models and that he would like the same deal again. John said that that's not a problem. You must cancel your license on the old bike and I will grant you a new and improved bike again on a perpetual basis. Paul is delighted and can't wait to get his hands on his new flash wheels and happily gives John back the old bike. Paul's elation is short-lived when John presents him the terms of the new deal for the flash new bike. To Paul's surprise, John is looking for another upfront perpetual licensing fee, except that this time it's €500. Paul was under the impression that he would simply continue to pay the maintenance costs and he would get the new flash bike. Not so, and when questioned, John points to the fact that the new bike has many additional new features.
Okay, that final presentation there, like really what the emphasis there was to demonstrate a material breach where John allowed Tim, his brother, use the bike, whereas that would have been a breach of the licensing, and really just to demonstrate there that with perpetual licensing, you can be caught by surprise when you want to upgrade to the latest editions, because the software vendors are not going to make that easy on you. And as I explained, you know what I mean, it's not just a case of switching over. There'll be a large payment involved. In the case of Paul here, it was €500. Okay, so key takeaways. So when talking about software licensing, we're essentially talking about exploiting the IP in the software, right? So we're really talking about selling a product. So therefore, it's important to set the pricing correctly from the very beginning. It can be very difficult to pull back a price point once you've gone to the market with a particular price. So equally, get to know what your target market is looking for from a B2C perspective. Consumers are generally happy with this with a software as a service style model that I spoke about briefly, but if you are going that route, be mindful of the myriad of consumer protection legislation when designing your booking process. In a B2B scenario, and depending on the software in question, larger enterprises can be wary of a SaaS style approach, mainly due to lack of control. It's also important to get things right from the start in terms of your contracts. So bad contracts and poorly drafted contracts will cost you customers, as you will eventually fall out with them, over what exactly the contract means. And lastly, match the technology to the contract. So if we discuss term licensing, if the license is for 6 months, make sure that it does in fact deactivate after 6 months. Okay, so that's it. Unless maybe there's some questions, and I'll just leave my contact details there in case anyone would like to contact me after the Lunch and Learn session.